Welcome to this presentation on disability discrimination on Jetstar flights. The following presentation is going to outline the case of King versus Jetstar Airways, which happened in 2012 after an incident of alleged disability discrimination against Mrs. King in 2009. In August 2008, Mrs. King had booked a flight on Jetstar flight JQ 769 departing from Adelaide to Brisbane at 9:45 a.m. on the 23rd of September 2008. She was later denied access to the flight due to two other passengers requiring wheelchair access whom booked before her, and the airline having a policy of only two wheelchair access patrons on any domestic flight using an Airbus model A320. The situation occurred on the morning that Mrs. King would fly from Adelaide to Brisbane after she called customer service to confirm her flight and that she would be taking her own wheelchair. She was told by the customer service attendant that she could not take her own chair in the cabin and that their chairs had been booked out that day. Mrs. King, who has post-polio syndrome, and had just finished attending the Australian Rehabilitation and Assistive Technology Seminar in Adelaide, felt that the two-wheelchair policy denied her the equal right of able-bodied people to fly and thus breached Australian anti-discrimination law. Mrs. King took Jetstar Airways to the Federal Court of Australia following the incident, claiming that the company's two-wheelchair policy breached Section 24 of the Disability Discrimination Act 1992. Section 24 of the Act covers goods, services and facilities and states that it is unlawful for a person who, whether for payment or not, provides goods or services or makes facilities available to discriminate against another person on the ground of the other person's disability. A, by refusing to provide the other person with those goods or services or to make those facilities available to other person, or in terms or conditions on which the first mentioned person provides the other person with those goods or services or makes those facilities available to the other person, or in the manner in which the first mentioned person provides the other person with those goods or services or makes those facilities available to the other person. At the time the case was presented, Mrs. King's lawyers believed that Australia was the only country where airlines could essentially cap the amount of disabled people on flights and stated that Ms. King is not seeking financial compensation, rather her hope is to change the Jetstar policy so that this incident does not happen to others in the future. They believed that the company's policy was unjust and should be remedied so future incidents would not occur. However, Jetstar was eventually able to win the ensuing court case, and Mrs. King was forced to pay the cost of legal action against them, with the court ruling that the cost would be capped at $20,000. Jetstar did not deny that the case was a form of discrimination. However, they were able to prove that the discrimination of Mrs. King was justified. This begs the question of how any form of discrimination can be deemed justified. The judge in this case ruled in favour of the airline due to their defence of unjustifiable hardship. Section 11 of the Disability Discrimination Act stipulates that for the purpose of this Act in determining whether a hardship that would be imposed on a person, the first person, would be an unjustifiable hardship, all relevant circumstances of the particular case must be taken into account, including the following. A, the nature of the benefit or detriment likely to accrue to or to be suffered by any person concerned. B, the effect of the disability of any person concerned. C, the financial circumstances and the estimated amount of expenditure required to be made by the first person. D, the availability of financial and other assistance to the first person, E. Any relevant action plans given to the Commission under Section 64. For the purpose of this Act, the burden of proving that something would impose unjustifiable hardship lies on the person claiming unjustifiable hardship. When defending themselves, Jetstar first had to establish the context of the case. As Mrs. King was suing them over the entire company policy of only 2 wheelchairs, they established that the case was based around the entire company's flight operations and that this specific case was a result of the whole operation. After establishing this fact, they went in pursuit of why their policy was defendable under Section 11 of the Disability Discrimination Act, covering unjustifiable hardship. Jetstar operates on the fact that they have a quick turnover period for their flights of about 30 minutes, and as a result can offer the low fares that they do due to low operating costs. They do accommodate for wheelchair access and average 0.5 people per flight, meaning more than 2 customers requiring wheelchair access on a flight was very uncommon. They then proved through studies from Mr. Labouchere that the time and resources needed to assist customers with special needs was limited due to the 30-minute flip time of planes. Jetstar's CEO then attested that to plan to accommodate more time would require their business model to allow an extra 5 to 10 minutes, having a domino effect on flights, resulting in up to 20 less flights per day, meaning the company would have to raise prices for all passengers or suffer major losses. They successfully argued that they would lose a lot of money accommodating more, when generally they rarely have more than 2 people booking requiring wheelchair access, meaning the cost of implementing a 3 wheelchair policy far outweighed the benefits of keeping the current 2 wheelchair policy. This specific case shone a light on Jetstar's risk management policies, and the rest of the presentation will focus on the decision-making process of the company when they chose to implement a 2 wheelchair policy. It will then take a look at the future for the company and whether they continue to take the risk of implementing the same policy or whether they need to reform the policy and how. It is important to first understand what is meant by the term risk management. Purdy defines the term risk, according to the AS/NZS ISO 31000-2009 guidelines, as the effect of uncertainty on objectives. The most effective way to understand Jetstar's decision to only accommodate 2 wheelchair-bound passengers at most requires understanding the risk management process and determining the company's objectives in context, then identify the risks, analyze them, evaluate them, and then finally to treat them. The following will run through what they would have been thinking about at the time of making their decision. The company has many risks that they must assess. However, for this part we will look specifically at the risks inherent in starting a 2 wheelchair policy on Airbus A320 flights. We begin by establishing the context for where these risks may occur. First, an A320 is a single-aisle smaller plane with limited capacity. Secondly, the organisation established itself in 2004 with the mission to offer low fares to enable more people to fly to more places more often. This was achieved through an efficient airplane turnaround rate, reducing airport costs. The time to turn around an Airbus A320 for the company is currently 30 minutes. Third, in providing the service of flights, the company must adhere to all laws and regulations of the countries that they operate in. Next, we will look at any of the risks that may be present when it comes to providing for a disabled person in a wheelchair. First, the duty of care. Upon accepting a reservation for any person, the company holds a duty of care to ensure they depart from a destination and arrive to a destination safely. Failing this can result in litigation in court. Second, having the necessary tools and staff capable of assisting a disabled person with embarking and disembarking a flight. Without this, such guests could not board, leaving the customer feeling, third, discriminated against on their disability, which is in direct violation of Section 24 of the Disabilities Discrimination Act of Australia. Finally, they must ensure that the systems function to maximise capacity, ensuring their promise of low fares to the public and high returns for their shareholders. Failing to do this will result in the company not being able to provide the service promised and unhappy customers. When analysing risks, the company must first look at the likelihood of a risk occurring. As the company has staff and the required tools, such as wheelchairs designed for cabins, the likelihood of breaching duty of care or not having the necessary equipment is very low. However, when it comes to keeping their promise of low-budget, high-volume services and not discriminating against the disabled, they run into a very troubling choice. They have a choice to set a maximum amount of people with the wheelchair disabilities that they can carry or to try and accommodate for everyone. Research shows that the company on average caters for 0.5 of a wheelchair dependent person per flight on any Airbus A320. Therefore, it would be very rare that more than 2 such people would want to board any given flight. Setting the standard at a maximum of 2, the company can ensure flights, on the most part, can be boarded and take off within their 30-minute window for plane turnover with low risk of customers feeling discriminated against. If they were not to cap all wheelchair-dependent persons from access to flights, they would almost certainly need to modify this, adding an additional 10 minutes to their plane turnover times. Next, the company would weigh up the consequences of any risks occurring. Should the company have a third customer wishing to board be denied access to the service, they may face legal action in Australian Federal Court under the Disabilities Discrimination Act 1992. If the company, however, changed their business plan to allow for more disabled guests to be able to board their flights, research showed they would need to expand their turnover time by at least 10 minutes. The result would be higher airport costs for all flights, and due to the domino effect of such an action, the company would service less flights per day than they otherwise do at the moment. The result would be a need to increase prices to cover these costs, or, keeping their prices the same, they would be far less profitable and less able to expand in the future. Taking into account and placing these options into a risk matrix, the company could better visualize what the best course of action might be. Option 1 represents enacting a 2 wheelchair-dependent person policy. At half a wheelchair-dependent person a flight, the likelihood of a third person jumping on board and having a problem with this would be very rare, though an ensuing court case representing a major problem would ensue should this happen. Option 2 sees accommodating all disabilities. However, this would lead to raising the prices, which is likely to turn away potential customers to other airlines, reducing profits dramatically. Third option is not much better, seeing accommodating all disabilities and maintaining the prices, which would massively reduce revenue, resulting in less expansion and investor resentment. After analysing the risks, Jetstar needed to evaluate them so they could make the best decision for all their stakeholders. In this case, they need to weigh up and take multiple perspectives, the first being the wheelchair-abled guest, followed by the able-bodied customer of any of their flights, and then finally their shareholders. From a wheelchair dependent's perspective, being denied a flight due to disability is humiliating. However, with 2 wheelchair policy, the chances of this happening are low. From an able-bodied guest perspective, was this policy to change, they may face higher prices for travel due to Jetstar changing their operations. The shareholders' perspective could see lower revenues due to keeping prices low to accommodate both able and disabled customers' desires for low-cost travel, and also from losing customers if they were to increase costs. The risk matrix shows visually that by implementing a two-wheelchair policy, they run a medium-level risk compared to the high-level risks associated with the other two options. Tartre defines 4 methods for treating risk: avoiding the risk, mitigating the risk, transferring the risk, or accepting the risk. Of the 3 risks established by Jetstar, the company needed to work out a way to treat them. Seeing that allowing no limit on the amount of wheelchair-dependent customers on flights would result in them needing to higher prices in order to cover costs or cover the costs themselves, the company felt that the risks were too high. By implementing a two-wheelchair policy, the company would most of the time not be discriminating against wheelchair-dependent people and would avoid the risks associated for revenue on their low-budget scheme. This meant, however, that they would need to allocate resources in case legal action was taken against them for the policy. Jetstar's ultimate decision was to accept the risk, as it was of medium level and may never affect the company. As seen by this case, however, they were eventually taken to federal court, but were found innocent due to the nature of this exact risk assessment. The implications of this decision could have a long-lasting effect, with other companies potentially being able to use risk assessment to justify a decision as necessary due to an unjustifiable hardship, or high risk. Having accepted the risks inherent with their policy, the company now faces 2 very pressing matters. The first is to do with corporate social responsibility and ethics, which is the continuing commitment by business to behave ethically and contribute to economic development while improving the quality of life of the workforce and their families, as well as the local community and society at large. Companies tend to engage in corporate social responsibility to create a sustainable business. Bearing this in mind, although the actions of Jetstar thus far can be deemed socially responsible according to their primary stakeholders, that being able-bodied and most disabled customers as well as shareholders, in providing their low-budget service, news coverage of the incident involving Mrs. King shed a negative light on the company. The company now needs to assess the risk of further exposure to their policies and whether they need to invest in new ways to address the issues of wheelchair-dependent people. The second risk to consider for the future is whether the federal government of Australia will amend and change the laws regarding disability discrimination. Following the end of Mrs. King's court case in 2012, the federal government of Australia stated that they would review the legislation. With continued pressure arising from groups about disability equality and fairer treatment, the threat of new, tougher legislation should be considered a threat. With the apparent risk of changes occurring, the company should consider this risk and assess whether they need to change their structure in order to accommodate wheelchair-dependent people better. If they achieve this sooner than later, the company won't have to struggle with a sudden change should legislation pass through the Australian Parliament prohibiting such policies that they currently undertake. To conclude, Jetstar Airways offers the service of budget airline travel, both domestically in its home country and abroad. The company set itself up to allow fast turnover times for aircraft in airports to reduce costs and pass these on to customers. The case of King vs Jetstar Propriety Limited shed light on how their cost-cutting could affect some of Australia's most vulnerable minorities. In order to bring these cost-cutting benefits, the company assessed the risk involved with having a two-wheelchair policy on domestic flights with an Airbus A320 aircraft. The risk of litigation was medium, and thus they ignored the risk so as to capitalise on budget travel for as many people as possible within Australia. This paid dividends until Mrs. King was subject to the policy and could not board a flight resulting in a court case that shed light on the company's actions. To remain a socially responsible and sustainable entity and to avoid future litigation, should laws change, the company should reassess the risks with their policy and potentially invest in research and development of new practices that would satisfy all stakeholders, including the wheelchair dependent. Thank you very much, and I hope you all enjoyed my presentation.